Vulnerability has been used ever since the CPR changed to explicitly take that into account. It's been a big thing for you.
It has.
Has the profession largely ignored it?
Yes, and they understandably so, I suppose. I mean, it places a tremendous obligation on a solicitor who isn't necessarily qualified or equipped to identify a vulnerability, and if they do, what do they do with it? It's so expansive, as I say, what could be a vulnerability, and it could be temporary, situational, permanent, actual or perceived. It's a whole different world. And also, as a law firm, how do you implement a practice that is consistent? Because it could also be subjective. One person's view of another person's vulnerability may be very different. So I do understand why it's been ignored from that perspective. I'm frustrated that it's ignored because, as you say, the legal services are usually purchased in a distress situation. So arguably almost everybody's vulnerable. So if you treat them all with that extra bit of care, you're going to satisfy those obligations anyway. But then there's been a little bit more of a pickup, although I'm not aware of any case law, I'm sure you may be. There's been a little bit more of a pickup from an appetite for law firms to start identifying and recording the additional time spent as a consequence of the vulnerability, with a view to, at some point, making an application to vary from the fixed cost regime because of that vulnerability. But then you've got the jeopardy of the 20% rule. 20% keeps appearing everywhere. I was going to ask you about the 20% rule. Does that mean you turn down a lot more Solicitor Act cases because of the 1/5 rule, etc.? But are you aware of any cases where a law firm has successfully tested the vulnerability aspect to depart from fixed recoverable costs?
No, I'm not. I'm not. It seems to have not been tested at all. But in relation to the 20% winning line for Solicitors Act cases, yeah, that's it's a major deterrent. And I think it's one of the things that the consultation ought to address, because I mean, it seems I can't understand the logic of saying that a solicitor who's overcharged by 19% suffers no penalty whatsoever, other than a reduction of the bill. It's potentially a vast amount.
Isn't that just a pragmatic thing that we don't want, the courts flooded with these cases, and it's just a bar to make sure that it's worth doing?
Yes, I suspect that was the initial intention, but it can produce extremely unfair results.
Well, there is always going to be something when you've got a cut-off point like that. There's always hard cases around the edges of it.
Well, yeah, but going back to the example of the £5,300, if you were going to take that to a full-blown Solicitor Act assessment, you just couldn't, because the costs involved in taking that to an assessment will far exceed £5,300. But like we say, that £5,300, that client was life-changing. So where do you go? I don't know. It comes back to the access to justice debate, doesn't it? I mean, and it all comes down to money at the end of the day.
But access to justice also means having courts not overwhelmed with cases as well, doesn't it?
Indeed, it does. You're right.
So, in terms of vulnerability, is that something you see with a lot of your clients, and that's something that hasn't been recognised?
Not specific vulnerability of that sort, but I go back to the point that all of my clients certainly the majority of my clients say that at the point that they signed up, they weren't concentrating on contract negotiations with their legal providers. And I mean, bear in mind, it's established law that the solicitor and client relationship is a relationship where there is a presumption of undue influence because of the solicitor's greater knowledge. So that, I think, really is the starting position in relation to signing up any client to terms of business. That there is a presumption that the solicitor is in a position to influence the client to sign their particular terms.
How do you approach vulnerability at the Ombudsman? There's probably something quite high on your agenda, isn't it?
That's a slightly tricky one for me to answer right now because we're in the Court of Appeal on a question about this. So it's a slightly awkward one for me to try and answer
in the context of
to some degree. But I think ultimately there are pretty clear regulations for when you take on a client as to what you should look for, and those are things that we would always want to take into account in drawing our conclusions. So there will be an exercise in us asking what work has been carried out at the outset to establish circumstances. More generally, during the retainer, there is a question of taking your client if you find them, and there always will be that. So to understand the individual circumstances, I mean, the example that you've given is an obvious one, really, for us as well. We wouldn't expect the way we would handle any other client that walked through the door. But equally, on the other side of that, you've got those clients where they are more sophisticated, or they've used the word before, and there might be a lot less information that's given, and the client then can't reasonably complain, I didn't get a client care letter on my 14th purchase using this firm, and therefore there was no retainer, I don't have to pay anything. I mean, that argument's just not going to wash. So if there is that side of it, there has to be the other, to say that there are clients that need more information, need more help, and that's your job to provide that. We very much see it in that light.
Now, I know the answer to this question is sign up to Legal Lexi. But ultimately, how do you evidence understanding? Aside from
the Legal
signing
Lexi.
up to Legal Lexi.
Is that a question for me?
Well, I guess, both of you, I suppose.
Well, traditionally, there certainly used to be a requirement for a discussion in relation to terms of business, and I would say that that's still best practice, a face-to-face discussion, pointing out if there are particularly onerous terms in the contract, and that may not be simply down to high charging rates or high success fees. It might be, for example, a contractual term that enables solicitors to deliver interim statutory bills which have the effect of making time run out for assessment, which the courts have repeatedly said are entirely prejudicial to clients. But that particular term is often buried on page 17 in small print, and clients are completely oblivious to it. If that term were explained properly, clients, if they knew they were able to, would shop around and go elsewhere and look for a firm that didn't undertake that particular task of sending out interim statutory bills. So I think best practice would be a verbal explanation, and as with other contracts, pointing out particularly onerous terms, and the more onerous the term, the greater the explanation that's needed to satisfy someone in due course that that's been informed consent to it.
Would you agree with that?
Almost all of it, I think. Really, I think there's a lot to be garnered from seeing who's in front of you and having that conversation, and that's a challenging thing. Although I suppose the generation below ours, if I can be so delicate as to put it this way, a lot of them don't want to speak to a person.
No.
And so those people are both the buyer of the house and the lawyer acting now to help them buy it, and they neither of them might have the inclination to say,
no.
What does this button do?
Absolutely.
It's a button, okay, let's have a conversation. So there are societal attitudinal changes, and it is a challenge for us because we will always say the same things to people. Go and speak to your client about this. If your client's got a beef, make sure they're comfortable talking to you about it, because it doesn't need to be a complaint. If they don't understand something, if you've used the word disbursement and this client has no one, who's ever used the word disbursements outside of the legal sector?
Profit costs.
Right.
Yeah.
Exactly. There are loads of these sort of industry terms that we will throw out, but they don't mean anything to anybody else on the street. So if the client doesn't understand something, make them comfortable raising the issue. And if that happens, these complaints won't generate because that dialogue exists. It might be done by WhatsApp now instead, but however it happens, make sure there is that opportunity, that golden bridge for the client to be able to have the conversation with the lawyer.
And I think, I mean, this is partly part of the same point, that with the change in attitude and the change in approach that people adopt to signing things. You know, when we sign up to Facebook, we flick through 50 pages of small print that we don't read and click a button at the end. And lots of retainers now are signed using precisely that method. And I think there should be some recognition that actually we live in an age where people's inclination is just to scroll to the bottom and press go because they want the service. Now, it could well be said that, well, you know, clients who do that are fools, but that doesn't take into account the fact that they aren't just signing up for a Facebook account or a tin of baked beans or whatever. They're signing up for something that's life-changing potentially, and probably in traumatic circumstances, but still the inclination these days is just to scroll to the bottom and press go.
It reminded me, the other week I was in a hotel and I checked in. There was this huge bit of paperwork to sign, and obviously just being me, you'd be surprised to nobody was sat there reading it. Right?
Did you?
And the woman said, "Have you got all day?" And I went, "I've got all night."